Good morning. A quorum being present, the subcommittees will come to order. Let me welcome everybody to a joint subcommittee hearing on H.R. 3441, the Save Local Business Act. We look forward to hearing from an excellent panel of witnesses who've traveled from different parts of our country to be here today. We want all of you to know who've come to be here with us that we appreciate the time you have taken away from your jobs and businesses to testify. To most Americans, the question over who their employer is seems to be an obvious answer. It's the person who hired them, the one who signs their paycheck. As a former labor attorney, I can tell you it used to be very clear in legal terms how you become someone's employer. But that's no longer the case since the National Labor Relations Board stepped in. Many people would be shocked to find out that some company they've had zero contact with is also considered their employer, in addition to the employer that actually hired them, signs their paycheck. Now, we all agree there are times when two or more employers should be deemed joint employers. Before the Nlra stepped in and overstepped, there was a common sense understanding of the circumstances establishing that joint employer relationship. Both employers had to have, quote, actual, direct, and immediate, close quote, control over the essential terms and conditions of employment. That standard made sense. But today, business owners and their employees face a standard vastly different and far more confusing. They face a situation where a group of unelected bureaucrats in Washington are interfering with their relationship in a way that has created a lot of problems. The NLRB's decision and the Obama administration's actions that followed it, in addition to a litany of rulings by activist judges, have inserted a great deal of uncertainty and confusion into the traditional employer-employee relationship. Two completely separate employers can be considered joint employers if they made a business agreement that, quote, indirectly, close quote, or, quote, potentially, close quote, impacts their employees. Indirectly or potentially. What does that even mean? It's vague and it's confusing. Think of it from the employee standpoint. There shouldn't be any room for question on who their employer is. As for employers, they should have the clarity they need to look out for their employees in the way the law requires. Because in order for employees to have strong protections in the workplace, it needs to be crystal clear who is responsible for providing those protections. If everyone is, no one is. We are here today because we are determined to provide that clarity once and for all and protect jobs and small businesses in our communities. I'm proud to say that three of our Democratic colleagues, Representatives Correa, Queller, and Peterson, are co-sponsors of the Save Local Business Act, and we hope to continue to build bipartisan support so we can restore common sense to the joint employer issue. This is an issue of great importance to both of our workforce subcommittees, which is why this critical legislation has been a joint effort with my colleague, Mr. Walberg. Chairman Fox has made the Save Local Business Act a top priority for the full committee, and this hearing will bring us one step closer to moving it through the legislative process. I'm going to give Mr. Walberg an opportunity to provide his own opening remarks. But before I do, I will yield to Workforce Protection Subcommittee Ranking Member Takano for his brief opening remarks. Mr. Takano.
Thank you, Chairman Byrne. We are here today to discuss H.R. 3441, the Save Local Business Act. But I believe this bill is more accurately described as a gift to large corporations that will further rig the economy against workers. More and more employees are working for a company whose name is not on the front of their office building. Instead of hiring employees directly, companies are renting employees from staffing agencies and then evading responsibility for upholding the rights of those workers, even though they profit from their work. For decades, joint employment standards have ensured workers can hold employers accountable for violating wage and hour laws or refusing to collectively bargain. This bill represents a significant and dangerous break from that precedent. It denies millions of workers the right to hold their employers accountable for wage theft and undermines their ability to have the responsible parties at the table in order to collectively bargain for better wages. This bill amends the FLSA and the Nlra to set a very narrow standard for who can be considered a joint employer. By setting a standard that is far more restrictive than the existing economic realities test used under the FLSA, this bill would seriously undermine worker protections. We'll hear today about a case involving workers at a Walmart warehouse that underscores the importance of the FLSA's joint employment standards. In this case, Walmart contracted out the operations of the warehouse to one company, and that company in turn contracted out the staffing of the warehouse. The contractors violated wage and hour laws. And because of the joint employment standard under the FLSA, 1,700 workers were able to bring Walmart and both contractors to the table to collect the pay that they had earned. The joint employer standard plays an important role in protecting the rights of American workers and combating the extreme and crippling inequality in our economy, which should be the central focus and top priority of this committee. Unfortunately, our focus and our priorities have been elsewhere. Studies have shown that for every dollar invested in high-quality early learning programs, there are $7 in economic returns. As a teacher, I know that improving early learning provides more children the opportunity to reach their full potential and puts more communities on the path to a better future. Yet this committee has only held 4 hearings or markups on early childhood education since the 112th Congress. In comparison, as the chart shows, during that same time, we have had 35 hearings and markups attacking labor unions and workers' rights to collectively bargain for better wages and working conditions. Now, there is a fine line between streamlining the economy and targeting workers' rights. And I believe this committee has moved well past that line several hearings ago. Even when we debate federal wage and hour standards, we're debating policies that would put financial stability even further out of reach for many workers. At no point since 2011, including in the 19 hearings and markups we've held on the subject, has this committee considered a single policy to raise workers' pay or create a fair playing field for millions of hardworking people who are struggling to make ends meet. Workers do not have the leverage in the workforce. The joint employment standard offers them the basic ability to hold both their employer and the joint employer liable for wage theft claims. This bill would strip workers of one of the few areas of leverage they have left. Victims of our two-tiered economy need this committee to realign its priorities. As this chart shows, a recent study found that wages for the bottom half of earners were stagnant from 1980 to 2014. In this same time, income for the top 1% grew by 205%. I'm going to say that again, 205%. So I challenge my colleagues, what are we going to do for the bottom half of income earners? I have great respect for small businesses, and I know the business owners here today will say that joint employer standards causes them uncertainty. And I'm not indifferent to your concerns. But I, too, am worried about uncertainty. And it's the uncertainty felt by millions of American workers who do not know if they'll be able to meet their basic expenses and provide for their children. This is the type of uncertainty that no one should have to live with, and it's the uncertainty that this committee is obligated to address. Thank you all for being here today, and I look forward to your testimony.
Thank you, Mr. Takano. I will now yield to my distinguished colleague from Michigan, Health, Employment, Labor, and Pension Subcommittee Chairman Walberg, for his brief opening remarks. Mr. Walberg.
Thank you, Mr. Chairman, and good morning to everyone. I too would like to extend a warm welcome to our witnesses who've traveled from out of state to join us today. We appreciate you being here and have had hearings on this issue in the past, and I'm excited for this again. I listened to my friends and colleagues on the other side talk about the things that we should be doing that weren't done when they were fully in control with the White House and both houses as well. So it is our time now to deal with things that I think make a difference in the real world of the American dream. This committee has been fighting to roll back the extreme joint employer scheme since it first took effect, and for good reason. It's a threat to jobs, entrepreneurship, and local employers across the country. We know this new joint employer standard has led to a whole host of real-world consequences, because that's exactly what we've heard from business owners and their employees in each of our districts before this committee. We've all heard the voices of local job creators who fear they could lose control of their business to larger companies. One small business owner who described himself as, and I quote, the living definition of the American dream, warned the committee that he would, and again quote, virtually overnight become a manager of a large company. We've also heard how this new standard has made it harder for small businesses to grow and create jobs in their communities. Christy Arslan, the owner of a small gourmet popcorn shop, said she was considering opening 5 new locations through franchising. But the joint employer threat made her expansion plans too risky. She decided she could only open 1 new store instead of 5. This is just one concerning example of lost jobs and opportunity. So many hardworking entrepreneurs who took a risk to start their own business now find themselves in the sea of uncertainty. And it's not just those in the franchising industry. Many small businesses and local vendors rely on contracts with larger companies, and they are concerned those contracts could soon be harder to come by. According to the American Action Forum, the joint employer scheme threatens 1.7 million jobs. To protect those jobs, we have to restore a common sense definition of what it means to be an employer. I'd like to remind some of our critics that the Save Local Business Act reflects the same straightforward joint employer test that workers and job creators relied on for decades. To be someone's employer, it makes perfect sense that you need to have actual, direct, and immediate control over terms and conditions of employment. This clear test does nothing to let employers off the hook for their obligations to their employees. What it does is ensure the actual employer is the one held responsible. And that's the way it should be. It's time to settle once and for all what constitutes a joint employer, not through arbitrary and misguided NLRB decisions and rulings by activist judges, but through legislation. This is obviously an area of labor law that is in desperate need of clarity. As recognized by at least 3 of our colleagues on the other side of the aisle, this isn't a Democrat versus Republican issue. The Save Local Business Act is about providing certainty for job creators in each and every one of our districts. It's about keeping the American dream within reach. I look forward to today's discussion, and Mr. Chairman, I yield back.
Thank you, Chairman Walberg. I now yield to my distinguished colleague from New Jersey, Congressman Norcross, the ranking member pro tempore on the Health, Employment, Labor, and Pension Subcommittee, for his brief opening remarks.
Thank you, Chairman Byrne and Walberg, for holding this meeting today. And I'd like to thank my colleague, Ranking Member Mark Cano, for what you do each and every day for working families. And certainly to the witnesses who you will be bringing your experiences to this issue. I'd like to start by offering my thoughts and prayers to the people of Texas and Florida and all those who have been impacted by the devastating storms over the last 2 weeks. There are 60,000 what they call storm break workers in those 2 states restoring power. One of the most dangerous jobs that you can imagine. But today we're here to consider a bill that attacks workers' rights to fight for better wages and conditions. Employers have increasingly moved away from direct hiring, relying on leased employees, subcontractors, permatemp. There's approximately 3 million Americans that are now employed by temporary staffing agencies, and 1/5 of all new jobs since 2009 have been through those temp agencies. Labor employment laws have long held that multiple joint employers, when more than one entity controls the terms and conditions of employment. This bill would rig the National Labor Relations Act and the Fair Labor Standards Act to make it nearly impossible for workers to hold joint employers responsible for unfair labor practices, wage theft, or others. Research shows that the fissuring of the workforce through increased outsourcing is already contributing to wage stagnation, and this bill would make that problem even worse. The joint employer standard that exists today started out in common law standard that has existed for hundreds of years. In America, that standard has existed through most of the 20th century and exactly intended to do what it is doing. But when the NLRB narrowed that joint employer standard back in 1984, it made it easier for companies to evade this joint employer. So from 1935 to 1984, it was the same standard. Hundreds of decisions were made based on that, and it wasn't until 1984 that that changed. In 2015, the NLRB considered a case where workers at Browning-Ferris BFI recycling plant wanted to organize a union. These workers were hired by the staffing agency Lead Point to sort recyclable materials at the BFI's facility. But BFI capped their wages and assigned the workers shifts. BFI claimed that it wasn't the employer, but here's the problem. If worker had joined a union with Lead Point as the only employer, then Lead Point wouldn't be able to bargain over anything without BFI's permission. Workers wouldn't even be able to bargain for better wages because the amount of Lead Point could pay was capped by BFI. The NLRB finding that BFI was a joint employer, and this is critical to help raise wages. So let's look what happened at the table. They're behind you and on the walls, showing the disparity in those wages since the Lead Point came into this equation. It made the wages of workers in nearly all the plants that have unions were from $19 to $30 an hour, plus health care, retirement savings. Lead Point only made $12.50 an hour, total package. Without being able to bargain with both of their employers, Lead Point BFI workers and hundreds of thousands like them will never see their wages rise again. And this isn't the only example, and we've seen these trends continue. Mr. Chairman, I ask for unanimous consent to introduce this document, which lists 3 primary cases that the Carpenters Union has dealt with into the record.
That objection so ordered.
Thank you. The right to join a union and collectively bargain helps workers raise wages. I've lived this. I fought on behalf of workers to raise wages for almost 2 decades. This bill enables corporations to keep wages low by subcontracting out the work. They are subcontracting their conscience to put profits over people. This bill even goes further. It amends the FLSA, the Fair Labor Standards Act, to prevent workers from holding employers accountable for wage theft, overtime violations, or others. It immunizes the employers from child labor violations. Under this bill, all a company has to do to outsource control is just one essential term of employment. Just one essential term of employment to its subcontracting. You could be scheduling. This bill relieves that company from any liability on wage theft for which it would be responsible. This is where I think the crux of what we're discussing today comes down to. This bill is pushing for a solution in search of a problem when it claims this bill would help franchisees. The current joint employer standards do not hurt, do not hurt franchisees in any way. There are approximately 800,000 franchisees in this country. The NLRB has never found one of them was a joint employer. 800,000, and not one decision to create a joint employer. It's a remarkable fact. But it's an important fact when we're talking about what we're trying to do here today. That's because the board carefully draws a line between what a franchisor maintains its brand, like requiring training on how to prepare hamburgers, hot dogs, or whatever else that the company produces. But they also do something now, the terms and conditions, wages, benefits, and hold that subcontractor to their exact standards. Mr. Chairman, I'm happy to work on this legislation and would help small businesses and raise wages. This bill does neither. It empowers massive corporations and stagnant wages at a time when working families need relief. I'll remind everybody, it's been a decade since a vote was taken on the minimum wage. It's been 8 years since they received a raise. We should be lifting people up, not pushing wages down. While we disagree on the merits of the bill, I want to thank the chairman for following regular order. I want to thank each of the witnesses for traveling to Washington and look forward to your testimony. Thank you.
Thank you, Mr. Norcross. Pursuant to Committee Rule 7C, all subcommittee members will be permitted to submit written statements to be included in the permanent hearing record. Without objection, the hearing record will remain open for 14 days to allow statements, questions for the record, and other extraneous material referenced during the hearing to be submitted in the official hearing record. Now, it's my pleasure to introduce our distinguished panel of witnesses. Our first witness is Mr. Granger McDonald. He is the CEO of McDonald Companies, a group of companies specializing in developing, building, and managing multifamily neighborhoods in Texas, and is testifying on behalf of the National Association of Home Builders. And Mr. McDonald, let me say, on behalf of all of us, we're all praying for the state of Texas. We appreciate you being here. Now I recognize Representative Lewis to introduce our next witness.
Thank you, Mr. Chairman, for holding this hearing and for introducing this very important piece of legislation to provide clarity and relief to local businesses and job creators across this country who are threatened by this joint employer scheme. It is my pleasure to introduce a local business owner from my state of Minnesota, Ms. Tamara Kennedy, who will be testifying on behalf of the International Franchise Association. She began her career as a secretary and worked her way up to owner by working nights in the restaurants while studying accounting and managing the books for a previous owner. Ms. Kennedy now owns and operates 9 Taco John franchises, 8 of them in the Twin Cities area. She epitomizes the American dream of work, investment, and risk. But America's economy's tolerance for risk is not unlimited. You know, her favorite part of the job is getting to teach young people how to be good employees and good teammates, an important role franchises play across this nation. Ms. Kennedy is serving her 2nd year as member of the International Franchise Association's Convention Committee and will soon be taking a seat on the IFA Board of Directors. I look forward to hearing about her experiences, and I thank her for joining us today.
Thank you, Mr. Lewis. I will now continue with this morning's introductions. Mr. Michael Rubin is a partner at Altshuler Burzon, LLP in San Francisco, California. Welcome, sir. Mr. Zachary Fassman is a partner in the Labor and Employment Law Department at Proskauer Rose, LLP in New York City. Distinguished panel. I now ask our witnesses to raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Let the record reflect the witnesses answered in the affirmative. Before I recognize each of you to provide your testimony, let me briefly explain our lighting system. You will each have 5 minutes to present your testimony. When you begin, the light in front of you will turn green. When 1 minute is left, the light will turn yellow. When your time has expired, the light will turn red. At that point, I'll ask you to wrap up your remarks as best as you are able. After everyone has testified, members will each have 5 minutes to ask questions to the panel. Now, I am not like really harsh about the lights, but sometimes people go a little bit over. We have a lot of members here that want to ask questions and only so much time for you and for them. So if I push you a little bit, please don't take it personally. It's because we're trying to keep everything moving. So when that light turns yellow, please start getting to the point where you're winding up. Okay. We all clear on that? Good. Also, before you testify, just as Mr. McDonald's doing, press the button for your microphone or we won't hear you. Good. Mr. McDonald, thank you. We'll look forward to your testimony.
Thank you, Mr. Chairman. Appreciate being here today. My business, McDonald Company, specializes in developing, building, and managing affordable multifamily housing across Texas. We currently own and manage 4,571 units in 41 different apartment communities in 25 cities. We directly employ 131 workers, from construction supervisors to property managers to maintenance and repair staff, many of whom are full-time salaried individuals. Beyond our regular staff, McDonald Companies contracts with 80 other companies and specialty trades to perform a range of services across all of our properties, including HVAC work, tiling, drywall, etc. This type of arrangement is not unique to the entire construction industry. It's made up of a system of building contractors and subcontractors who have business together. For the most builders, they don't have enough work to hire someone full-time to just do tile work, for example. I might only need drywallers for a few weeks each year. For these numerous specialized tasks require a complete project, we contract with other small companies out of necessity. This is why I'm very concerned about the ongoing ambiguity over what constitutes a joint employer. A builder can now be considered a joint employer if he has indirect or potentially ability to exercise control over the work of subcontractors. The question of what can be deemed indirect control and when it's legally constitute joint employment has been left to an open-ended situation by the NLRB. This threatens to upend the foundation of the entire industry. For example, we'll schedule a painter or an electrician to come to a job site at a certain time. Does that trigger a finding of joint employment? Do I have indirect control if I ask a contractor to bring on extra staff to make up for delays? One might think that an indirect or potential control over just one factor like scheduling would not justify a finding of joint employment. But because the indirect test is so vague, the NLRB has not ruled on that possibility. And there is nothing stopping the courts from ruling on the basis of just one factor. Over the last 3 weeks, I've been overseeing cleanup and reconstruction efforts at some of our buildings in the wake of Hurricane Harvey's historic devastation. The process of rebuilding from a natural disaster is chaotic, and timelines are anything but predictable. I have contractors and subcontractors coming in and out of our properties round the clock right now. I may ask a contractor to bring on more staff to finish up drywalling that has fallen behind so that the next stage of workers can get started, or tell the cabinet installer they can't come as planned because the replacement floor tiles have not been set and because of lingering humidity because of the storm damage. Could these acts meet the test for indirect control? The expanded joint employer test provides no clarity. My focus is on getting families back into their homes. We have endured and rebuilt from bad storms before, and we're doing it again. But this time is with the added worry of whether my company will be held liable for the practices of contractors, third-party vendors, and suppliers that we've hired to help with this important job over whom we have no direct control. The reality is that the line that once clearly separated two employers is so blurry that neither I nor ability will only grow for builders as courts explore and expand the limits of the new standard. Exposed to unlimited and unpractical joint employment liability, small businesses will find it increasingly challenging to comply and therefore compete. This is true for residential building firms, the majority of which have less than 10 employees, as well as specialty trades. With less competition among small firms, construction costs and subsequently home prices will rise, particularly troubling for those of us who are in the business of providing affordable housing. The bipartisan Save Local Business Act offers a common-sense solution to the ambiguity created by the Browning-Ferris decision by affirming that a company may be considered a joint employer of a worker only if it directly, actually, and immediately exercises significant control over the primary elements of employment. This is reasonable. I should be held accountable for my employees, but not for those of another company. Codifying the definition will provide the legal certainty every business owner needs. I urge the committee to take swift action to advance Save Local Business Act. Thank you.
Thank you, Mr. McDonald. Ms. Kennedy, you are recognized for 5 minutes.
Chairman Byrne, Chairman Walberg, Ranking Member Takano, Ranking Member Norcross, and distinguished members of the committee, subcommittees, good morning. My name is Tamara Kennedy, and I'm the president of Twin Cities Taco John's, a multi-unit franchisee based in Minnesota. I'm honored here today to speak here on behalf of small businesses throughout the nation, and I thank you for your invitation. I want to start by recognizing that all of our prayers and thoughts are with the people of Florida, Alabama, Georgia, South Carolina, Texas, Louisiana, all of whom have been affected by the hurricanes Irma and Harvey. Today I'm representing the Coalition to Save Local Businesses and its thousands of members who are supportive of the Save Local Business Act. I'm appearing before you today with over 400 franchise brand leaders coming around Capitol Hill, urging their representatives and senators to take a close look at this legislation. We consider H.R. 3441 the most important federal legislation in franchising in over a generation. Mr. Chairman, I got my start working as a secretary for a Taco John's franchisee. It took me 17 years to realize my dream of owning my own business, and in 1999, when my employer retired, I bought the restaurants. Today, my organization operates 9 locations, 8 in Minnesota and 1 in central Iowa. My business has overcome many challenges, including the recession, but we have stayed the course because I believe our company has the potential for growth, should the regulatory environment allow us the certainty and the flexibility to do so. Countless people in the franchise industry start out in entry-level positions like mine, as busboys, line cooks, or cashiers, or as secretaries, working towards their dream of someday owning their own business and being their own boss. The franchise structure has created that path. As a local business owner, I'm very fortunate to have the privilege of providing jobs in our neighborhoods. My company's values really are about giving people a place to earn a living and learn skills at the same time. It's the greatest honor a local business can have, to pay forward the opportunity to learn how to be good employees, good teammates, and eventually great leaders in their own right. I'm here today to encourage this committee and this Congress to act on the legislative solution to address the joint employer problem pending before the subcommittees. It is important that you know how much I love my brand and that partnership that I have with Taco John's. If you've ever heard the phrase or used the phrase Taco Tuesday, I'm proud to say you're using a Taco John's trademark. But now, after 2 years operating under the expanded joint employer standard, the impact of my business is clear. Joint employer means I must pay more to run my business and earn less in return. Franchisors, including mine, have been compelled to consider the potential liability risk of the new joint employer standard that the National Labor Relations Board has imposed. Changing the rules language with less clear, more widely interpreted definitions of joint employer by adding words like indirect and even reserved or unexercised control opens up very real concerns. Some examples. My franchisor used to provide employee management products as options for franchisees. Basic but essential tools like job descriptions, performance reviews, and employee handbooks, and recruiting tools like banners, flyers, and ad copy used to be available. But due to expanded joint employment liability, the company no longer provides most of these tools. Now I must hire an outside attorney to write an employee handbook. That employee handbook cost me $9,000. And just this year, we no longer have access to a branded job application form from the franchisor. I must create my own application or use an off-the-shelf, non-branded form. The reality is that joint employer is impacting my ability to recruit employees. Quite simply, we want and need employees to consider our business when they're searching for a job. It could not be more important today to have a powerful, creative, system-wide set of employment tools. I don't blame our brand for some of these changes, because I know they're watching what's at stake for everyone. Our brands are coming under attack for involvement in the hiring process, which some believe indicates a direct relationship with my employees. Those of us running our businesses know that's simply not the case. My view and my brand's view is that my employees are my employees alone. My brand's role is to provide me with tools and never to exert control over my employees. In its August 2015 decision to expand the joint employer, the NLRB removed the clear understanding from our business relationship, and now the industry is justifiably struggling with this new legal landscape. Chairman Byrne, Chairman Walberg, and on behalf of the Coalition of Save Local Businesses, thank you so much for introducing the Save Local Business Act. The expanded joint employer standard is simply not working. It's time we provide some security to local business owners. Thank you.
Thank you, Ms. Kennedy. Mr. Rubin, you're recognized for 5 minutes.
Thank you. Let me begin by thanking Chairman Byrne and Walberg and Ranking Members Norcross and Takano for this opportunity to testify about the impacts of the Save Local Business Act. I've been representing low-wage workers for more than 35 years. My clients include janitors, security guards, warehouse, garment, fast food workers, and others. For these workers, and for many small businesses operating in the low-wage economy, H.R. 3441 will have disastrous consequences. The bill purports to redefine the term joint employer under the NLRA and FLSA, but its practical effect will be to completely eliminate joint employer responsibility under those statutes. The proposed definition narrows the NLRA's common law standard and the FLSA's direct or indirect suffer or permit standard so dramatically that no company could meet the definition of joint employer once it contracts out any direct control over its workers' employment. The bill exempts from joint employer responsibility any company that does not exercise direct and significant control over all essential terms and conditions of its workers' employment. That means once an employer has delegated any significant control over any terms and conditions of its workers' employment, it has ceased exercising direct control over those terms and conditions and is no longer a potential joint employer. Why does that matter? In the low-wage economy, wage and hour violations, discrimination, and other unlawful conduct are rampant. All too often, though, the injured workers have no real ability to enforce their rights, even in the face of flagrant violations, especially when their direct employer is an undercapitalized labor services subcontractor. In case after case, we have seen law violating subcontractors, whether they supply garment workers in Los Angeles, janitors in Texas, or warehouse workers in California or Illinois, simply declare bankruptcy in the face of a court judgment for back pay or other relief, while their owners or their owners' relatives or business partners later incorporate under another name to carry on the company's same business, leaving the judgment unsatisfied. The proposed definition of joint employer would leave without remedy the workers most in need of statutory protection, the at-will non-union employees who are most susceptible to exploitation. It would also leave small business owners in the difficult position of being solely responsible for labor law compliance and collective bargaining, even when they lack sufficient authority and control to meet that responsibility. The problem faced by small businesses is not that a court might impose joint employer liability on the company that shares their control over the workforce. The problem is the small business's economic dependence on that larger company may leave it no choice but to accept that shared control without correspondingly shared responsibility. The proposed bill radically redefines joint employment under the FLSA and NLRA, abandoning the statutory directly or indirectly suffer or permit standard that has been key to effective FLSA enforcement since 1935 and rejecting the common law of agency-based NLRA standard. Under the proposed bill, it would be easier to prove a company's responsibility for wrongful acts committed by an employee against a stranger under the traditional common law master-servant standard than to prove that company's own responsibility for wage and hour violations committed against its own employees. This turns the purposes of the FLSA and the common law standard on its head. There's no need for these changes. Any lead company that does not want to be responsible for bargaining over workplace conditions it controls can simply restructure its relationships to give its suppliers greater independence in controlling wages, hours, and working conditions. In my law practice, I've seen the destructive impacts of the fissured economy and the critical need for meaningful labor enforcement in many industries. Let me briefly share one example, as mentioned by Representative Takano. In a case we settled a few years ago in Southern California, hundreds of warehouse workers were employed in 4 warehouses, loading and unloading trucks for deliveries to Walmart distribution centers. Walmart owned the warehouses and their contents. It contracted with a subsidiary of Schneider Logistics to operate the warehouses, and Schneider in turn retained 2 labor services contractors to hire the workers. By contract, all responsibility for legal compliance rested with the contractors, yet Walmart and Schneider retained and exercised control over almost every aspect of those workers' employment. We ended up settling that case for $22.7 million. Class members got tens of thousands of dollars in recovery and significant injunctive relief that stopped those violations, that increased the wages and allowed health benefits for the first time for those workers, only because the courts made preliminary findings of joint employment.
Rubin, you're beginning to run over. Can you wind up, please?
Absolutely. The proposed bill would have required a completely different result in that case. None of those defendants would have been a joint employer under H.R. 3441. The new narrow definition would have left those workers and millions like them almost completely without recourse. I'd be pleased to answer your questions.
Thank you, Mr. Rubin. Mr. Fassman, you're recognized for 5 minutes.
Chairman Byrne, Chairman Walberg, Ranking Member Takano, Ranking Member Norcross, and members of the committee, thank you for inviting me to testify today. I'd like to address my remarks to the legal issues that are before this committee. As this committee knows, beginning in 1984, the National Labor Relations Board and the courts instituted a standard in which the courts determined whether 2 separate entities were joint employers by applying exactly the standard set forth in this bill. The accepted test was and should be whether the alleged joint employer's control over employment issues was direct and immediate. The NLRB and the courts properly distinguished direct and immediate control from situations where the alleged joint employer's supervision was limited and routine. And I want to emphasize for the committee, this is not a new standard. This is the traditional standard that was followed by the NLRB and the courts in hundreds of cases for more than 30 years. This bill would simply restore the law to where it was before the NLRB's decision in Browning-Ferris. Now, why is this important? The key for me is that the traditional standard is based upon facts, the actual conduct of the parties, as opposed to hypothetical, after-the-fact legal conclusions about indirect or potential but unused authority. The traditional standard affords stability and predictability by asking a factual question. Who actually makes employment decisions? I want to emphasize that this standard does not prevent collective bargaining. It allows collective bargaining between unions and the employer that actually hires, fires, disciplines, supervises, and directs the employees. In Browning-Ferris, the NLRB abandoned facts and actual conduct and created a new test based upon whether the alleged joint employer has the potential to control aspects of the workplace, either directly or indirectly, whatever that means, even though it's never exercised that authority. In other words, the Browning-Ferris test is not based upon the party's actual conduct, but turns on after-the-fact legal conclusions about who has what potential authority. That test is not based upon the common law. Indeed, in my view, it is no test at all. As the dissent in Browning-Ferris observed, virtually every business that subcontracts part of its operations falls into this category. Contracting parties will always have the potential economic control over the relationship, even though they've never exercised it. And that's the key problem with Browning-Ferris. It makes virtually every business that subcontracts any of its operations into a joint employer. This standard negates freedom of contract and allows imposition of joint employer liability after the fact through administrative determinations about the level of potential or indirect control retained but never exercised by the joint employer. It destroys any level of predictability in thousands of vital commercial relationships. For me, as someone who's negotiated many contracts, the justification of this standard because it is allegedly necessary for meaningful collective bargaining makes no sense. In fact, to me, it's just the opposite. Adding in an employer that has potentially conflicting interest, that is a third employer or a second employer, into the bargaining sessions will make it much more difficult to reach agreements, not easier. And I can tell you from experience, it's difficult to reach agreements between one union and one employer, let alone multiple employers who have conflicting interests. Applying such a broad definition of joint employer also undermines the Taft-Hartley Act, where Congress confined labor disputes to a dispute between the primary employer and outlawed secondary boycotts, outlawed secondary picketing, and involvement of a broader series of employers. A joint employer could easily be considered, under this standard, under the Browning-Ferris standard, might easily be considered sufficiently related to the primary employer to allow picketing at the joint employer's facilities, and that's contrary to Taft-Hartley. A slightly different question is raised under the Fair Labor Standards Act, which does have different definitions, but under that act, there's a crying need for a definition of joint employer. As I've said in my written comments, there were 9,000 Fair Labor Standards Act lawsuits filed in 2016 alone. That's not 9,000 total in the courts, that's 9,000 new lawsuits. And there has never been a clear definition of joint employment under that act. There is a crying need for a clear definition. And my colleague on the panel has cited a case called Salinas versus Commercial Interiors, where the Fourth Circuit in 2017 goes through all the different standards, itemizes them, comes up with a clearly unworkable new test. That goes on all the time, and it's time for Congress to say,
you're going to have to wind up too.
let's get a definition that works, and in my view, this one would work under that act.
Thank you, Mr. Fassman. I'm a lawyer. We just can't help ourselves. We can't stick to the time frame. I understand it. But I do appreciate all of your testimony. That was excellent for all of us. Now we get to the time period where it's question and answer time from the members of the committee. Let me remind the members of the committee, of the subcommittees, and the witnesses, each member gets 5 minutes. So however many people he asks, it's just 5 minutes for that one member. And we're going to try to stick to that as close as we can because we have a lot of members here today. We'll start off our questioning from the distinguished chairwoman of the committee, Dr. Fox from the great state of North Carolina. Dr. Fox, 5 minutes.
Thank you very much, Mr. Chairman. I want to thank all of our members for being here and certainly thank our panelists for being here today. Their testimony has been great. Mr. Fassman, I want to start with you because I think you gave such a wonderful statement at the beginning about the traditional standard being based on facts. You know, I think that's so important that we continue to talk about that and that the Browning-Ferris decision based on potential authority and on intent, not action. I think too many times in our culture these days, there is this decision to judge people on intent and not action. And I thank you so much for making this so succinct. It's been suggested that the BFI standard is not as broad as some claim and that business owners should not worry about it. Do you agree?
Chairwoman Fox, thank you for your comments. I don't agree. I think that the potential in this standard, to use the standard's own terms, is amazingly broad. The potential to control a relationship, I think basing a decision upon that sweeps everything into the standard, so I would not agree with that.
So your concern is that the potential application of this expanded standard is far-reaching. Is there anything in BFI that serves to limit its application so business owners we have here today should not be concerned? And on the other hand, would the joint employer standard in Save Local Business Act be limited in such a way as to assuage business owners' concerns?
Well, I think there is nothing in BFI that suggests a limitation, and that indeed is the problem, as the dissent observed in BFI. And the standard in this bill restores the law to what it was, and the law that we've lived under for 30-plus years. So I think that people should take some comfort in that. There are many, many decisions applying the standard that's in this bill.
Thank you very much. Mr. McDonald, my husband and I were in construction business for many years, several times in our lives, and we did a lot of subcontracting with people, so I understand a little bit about your business. Does your company have any way to control all the actions of your vendors or subcontractors that you could be held liable for under expanding joint employer definitions?
Well, thank you very much, and I'm glad that you got out of the business and found good work. It was a good move. You know, under Browning-Ferris is so overly broad, and it doesn't provide employers with clarity so we know where we're headed. You know, we all agree that there needs to be some common sense guidelines, and that's what we're not seeing currently. Essentially, we're working under a scenario where you'll know it when you see it if it's bad. I mean, which doesn't give anyone any certainty as to what's going forward or where we're headed with all this. And we don't have the opportunity to direct every single task with our subcontractors. We don't set the price. We don't do anything like that. And we certainly don't do any more than just scheduling our folks when we need a task done, which is, you know, this morning at breakfast, I got a menu, I selected something, the gentleman brought it to me, I asked him to hurry. You know, was I scheduling him? He didn't bring me what he wanted to bring me for breakfast. You know, and it seems facetious, but it's really the same thing.
Right. Well, Ms. Kennedy, I would like to know if you would have been able to have gained the same level of experience as an employer without the franchise help, and would you have been as eager to become a franchise owner yourself if you knew the franchisor would have had such a level of control over your business?
Thank you. No, there's no way that I could have gained that experience without following the path that I did through the course of franchising. It is one of the true quintessential American products franchising is. It gives us the opportunity to learn all of the many important parts of running a business, but gives us the security in knowing that we're working with a proven process. So it limits the risk that we take when we go into business for ourselves. It's important to remember that that same path that I followed, I hope more people can, and that's what we're risking here if we don't get this fixed.
Thank you, Mr. Chairman. Thank you, ladies and gentlemen.
Thank you, Madam Chairwoman. The chair now recognizes the ranking member of the full committee, the gentleman from Virginia, Mr. Scott.
Thank you,
5 minutes.
Thank you, Mr. Chairman. Mr. Rubin, you have a copy of the bill in front of you. On
Yes.
page 2, line 8, it says a person may be considered a joint employer only if such person directly, and then goes down to has exercises significant control over the essential terms of employment, including hiring, firing, determining rates of pay and benefits, day-to-day supervision, assigning work schedules, positions and tasks, and administering discipline. As it to be called a joint employer, you would have to do all of those?
Under the language of the bill, you have to do all of those, which is why.
Okay, so if you do everything, if you hire, fire, determine rates of pay, but you don't assign individual work schedules, you would not be a joint employer under this definition. Is that right?
That is right.
Now, exactly how would your right to negotiate wages as a union work if the person who hires, fires, and determines rates of pay and benefits is not at the table?
You can't. And contrary to Mr. Fassman's testimony, and as the board made clear in Browning-Ferris and later in Miller and Anderson, it's only if the companies that can actually control the essential terms and conditions are at the table that you can have meaningful bargaining.
In Mrs. Kennedy's testimony, she said that the franchisor used to have employee handbooks, a job application form, and helping recruiting employees. Would anybody doing that ever be considered a joint employer?
Well, in the Freshie case, the advice memorandum by the board's general counsel, he made clear that a franchisor would not be liable for making available handbooks and other materials as long as they're optional. The circumstances that Ms. Kennedy described would not, under the board's current view, trigger joint employer liability, which is why of the 800,000 franchisees, none have ever been found in a joint employer relationship.
Mrs. Kennedy, in light of the fact that 800,000 franchisees, none of the franchisors have ever been held joint employment, I'm trying to find out what the problem is that you are articulating. Did lawyers help prepare your testimony and interpret the laws, give you advice on that?
No,
Who prepared your testimony?
I did.
Now, why do you think that, where'd you get the idea that a franchisor might become a joint employer?
We are taking a look at all of the many written articles that are out there in not only the franchise space, but in all business magazines, and trying to understand how our relationship is changing right now with our franchisor, and trying to determine where we're going to head as a partnership with
And are
them.
lawyers helping you get through that?
No.
Okay, well, I think that most of the lawyers are suggesting, as Mr. Rubin said, that there's 800,000 franchisees, not a single franchisor has ever been declared a joint employer. And so we're trying to find out what the fear is. If they are joint employers, they will be responsible for what they did. If they are controlling the wages, then they would have to be subject to the NLRB. If there, Mr. Rubin, if there is a OSHA violation created by the franchisor, would the franchisor be a joint employer under present law or under the bill?
Under the present law governing OSHA, yes. Under the bill, absolutely not, because under the bill there is no joint employer anymore.
And if there's a wage, if there's a failure to pay overtime directed by the franchisor, under present law, would they be a joint employer for that purpose?
Yes, and there are many examples of that, but under the current bill, they would not be a joint employer because there are no more joint employers who control every single term and condition directly and actually.
And how does the bill return us to the traditional definition of employer?
It doesn't at all. The traditional definition of employer under the FLSA is directly or indirectly suffers or permit. It's a completely different standard, the most worker protective standard ever enacted by this Congress. And under the National Labor Relations Act, the Supreme Court said you return to the common law standard. So if you actually read the Browning-Ferris opinion, you see them extensively quote from the Restatement of Agency, 1933, 1958, which states the legal standard, which the board adhered to. And the test in Browning-Ferris, despite what I'm hearing about prospective and indirect, is very clearly stated in the context of collective bargaining. If they have to be employers within the meaning of the common law, which includes direct and indirect, and if they share or co-determine those matters governing the essential terms and conditions of employment. That is the standard that has always been applied. That goes back to the beginning of the National Labor Relations Act. That is the standard that should continue. And of course, these are fact-based inquiries under
Mr.
any
Rubin,
standard.
we're going to have to wind up.
I'll end it there.
Thank you, Mr. Scott. The chair now recognizes the chair of the Subcommittee on Health, Employment, Labor, and Pensions, Mr. Walberg, for 5 minutes.
Thank you, Mr. Chairman, and thanks again to the witnesses. Ms. Kennedy, thanks for grabbing the whiplash by the tail of Franchisee and going for the American dream, as you have, and we applaud you and congratulate you. You spoke about receiving less assistance and help from your franchisor due to the expanding joint employer standards and the fear that these programs will create unintended joint employer liability. Could you further explain why this type of assistance is so critical to the franchisee and to all business owners, and especially first-time business owners who are in the franchise system?
Thank you. I'd be glad to. What's important to remember is that at the heart of franchising is someone's idea. I make really good tacos, but that doesn't make me an expert in legal matters. It doesn't make me an expert in construction. It doesn't make me an expert in all of the things that it takes to run a business. When you join a franchise, when you choose to partner with a franchise, you get some of the support in those areas that you're looking to learn more about. It lessens the risk, and it creates the opportunity to grow faster, become more profitable, and put more people to work. It is, for me, probably one of the most important parts of this is to try to understand that my employees are my employees, and I get to pick them. I get to watch them grow and move on and through our company on to better things. And my employer doesn't have any role in that employment process other than to supply me with what I desperately need right now, which is really good recruiting tools and training tools to keep people growing into what they're going to become. And where we're at now is, does that make them potentially indirectly responsible for part of the employment process?
We'll go on with that. What problems that may develop and be created in an expanding joint employer standard that isn't reined in? What additional problems would you see?
Goodness. Trying to wait to see whether or not we want to use the court system to decide whether or not there was indirect control, whether or not there is reserved and unexercised control, means that I'm not going to be able to open restaurants as much, as often as I'd like to, and at a speed that I think that I could, because I'm not sure whether or not I'm eventually not really going to be an owner if I'm in some way just a middle manager, because my franchisor is somehow indirectly responsible for my employees, and that's concerning.
Thank you. Mr. Fassman, your written testimony noted that bringing two or more alleged joint employers to the bargaining table in a union contract negotiation may result in conflicts of interest between the two employers. Do you think this would result in better deals for employees, and would it promote labor peace?
Chairman Walberg, I don't think it would promote labor peace at all, and I don't think it would promote better deals for employees. I don't think it would promote deals, because you'll have two employers with differing viewpoints pointing fingers at each other, saying it's your responsibility, no, it's your responsibility, and nothing is likely to get done in those circumstances. So, no, I don't think it's a better deal at all.
Okay. Mr. McDonald, you spoke about shortages of workers and especially construction trades, and we hear about that all over our districts, all across the country. It seems to me that one of the driving forces to get workers into specialty trades would be the potential to own their own business someday after they learn the process. Do you think the expanding joint employer standard could take away that incentive, and how might this impact the construction industry?
Well, it'd be an extreme negative impact. You know, most of our smaller subcontractors now are the ones that do the majority of the work. They're people that have under 15 employees total in their shop. They're the great American dream. They're the guys who started off as a journeyman and made their way to a master status, and then started their own companies, and with their own sweat and blood have gotten it done. And they're not out trying to do anything but a good job. Most of the people in the construction industry, the home builders that I represent, are just like myself. I started off in a pickup truck with a toolbox. And we've built a very good company. We've been blessed, and we've gotten a lot done. And we've made a lot of good, safe, affordable housing for Americans because of it. With the storm that we've had in Texas, and it's occurred in Florida, we're going to be short, in Texas alone, somewhere between 10 and 20,000 construction workers, just to put people back in the homes where they work. Not to accelerate to a new level, just to bring us back to where we were. And anything that we do that stymies the effort to keep people in business, to keep people going, is just going to make it more and more impossible to put people back at home and back at work.
Thank you. My time has expired. I yield back.
Thank you, Chairman Walberg. The chair now recognizes the ranking member of the Subcommittee on Workforce Protections, Mr. Takano, for 5 minutes.
Thank you, Mr. Chairman. Mr. Rubin, In your testimony, you mentioned the case you litigated involving warehouse workers in a Walmart Schneider facility. That case hits close to home. In fact, the facilities at question are in my congressional district. The case of these workers takes what to many seems like a technical legal debate and puts a face to the workers who are protected by our joint employer laws. I want to give you a chance to share a little more about the facts of the case.
Sure. 1,700 workers, many earned far less than the minimum wage. They earned money based on a bogus piece rate, where because the company up the ladder paid the labor services contractor on a piece rate per truck loaded or unloaded, the contractor in turn paid the workers depending on how many trucks were loaded or unloaded on a shift among the 4 warehouses at the same time. So no worker had any idea what any other worker was doing in terms of loading or unloading, whether those numbers were accurate. Many of the workers had to sign their pay stubs when they went to work in the morning, and the supervisors filled those in later with whatever hours the supervisors claimed should be in there. The workers had to show up hours before the work began. They weren't paid for those hours. The workers were often sent home early when there weren't enough trucks to unload. They weren't paid for those hours. There was a whole series of egregious labor violations that went on for decades in those warehouses, and that was the basis of the lawsuit. And the control was exercised by Walmart and by its operator by dictating the terms and conditions of employment, acting indirectly through the next level down. Indirect simply means you're using someone else as your agent. You're telling that next company down what to do, how to do it. Your instructions are carrying through to the workers. So the ultimate responsibility was held to be shared by all of the companies.
Yep, so that's a horrible situation for those workers, terrible working conditions, being cheated out of their pay. What remedy would they have had if this bill were to pass?
They would have no remedy at all. Their only recourse would be against the labor services contractor, who, as we found out when we finally entered into settlement negotiations, had only enough money to pay, I think it was about 7% of the total settlement combined over a period of years. What happens in real life when you're talking about the facts is that as soon as there is a threat of labor organizing, as soon as there is a threat of a wage and hour lawsuit, the company up the ladder terminates its contract with a small business. If small businesses are concerned, the concern should be based on the fact that they have no job security. What happens is they lose their contracts and the workers lose their jobs as soon as one worker complains. So if a worker complains, not only is that worker out of a job, but all of his or her co-workers are out of jobs too, because the labor services contract is terminated.
Let me get this right. So right now, I mean, the law gives some protection to these workers, but if we pass this new bill, remedies go away for those workers. And you're telling me that even the small business, that the contractor with the big business, becomes even more vulnerable under this law.
That's why I don't understand why this is called the Save the Small Business Act. The small businesses are the ones who are caught in the squeeze. They're the ones who are hurt by this language because they will bear full responsibility even if they don't have full responsibility.
So this really should be called the Screw Workers and Screw Small Businesses Act.
Not for me to say.
I'm sorry for using such a word, but
that's the effective impact.
So I'm curious about as to whether this bill creates perverse incentives that could harm franchisees or smaller businesses that operate as subcontractors to larger firms. Under this bill, could franchisors or warehouse owners exercise exceptionally broad control over the labor relations of its franchisees or subcontractors, but enjoy immunity from liability for employment law violations associated with that control?
Yes, that's exactly what can and would happen.
Ms. Kennedy, did any of you didn't ever consult any lawyers, but did you ever read in your articles about this possibility that that your franchisor could exercise far more control over your operations, but yet put all the liability for violations onto you?
I have read information about that, but I'm always...
Did you ever talk to your own attorney, not the franchisor's attorneys?
I do have counsel on
Let me just
other
interrupt for a
matters.
second.
Wait, Mr. Chairman, this is my time.
Well, let me just, I'm going to give you your time. The communication between an attorney and client is privileged, And I don't think you mean to insert yourself into that privilege and get her to divulge
No,
something.
Mr. Chairman, I'm not. I just want to know if
Then I don't think we
she's
should be
consulted
ask-
her
I don't
own
think we should be
attorney or
asking
their
about-
company's attorney.
We should not be asking her about what her attorney told her. That's
Mr. Chairman, this
inappropriate.
is my time.
I'm going to let you have your time. I'm just saying, she
Well, it
has
is
a
my time, Mr.
recognized
Chairman.
privilege, and we cannot invade that privilege here.
Okay. Well, Ms. Kennedy, have you consulted your own attorney about this? Not a franchisor's attorney?
Yes.
Okay. Well, I'd be interested to know just whether or not, whether you have any advice on whether the company's control, the franchisor's control, would leave you in a more vulnerable situation, more liable.
I don't know that I have any information or advice that I want to share about that today. I don't think that that's really what I'm here to talk about. It hasn't happened. I can't speak to what has happened. What I'm most concerned about is that it could happen if we don't find a way to bring this language back into what is my reality, which is defining what is direct, immediate control over employees. It's the language that we've always worked under. Those employees that I have, I'm proud of, and they work for me. And when we use these words like indirect or reserved, unexercised control, that's where the danger is.
Well, thank you for your response, Ms. Kennedy. Thank you.
Mr. Chairman, if I might,
Nope, we got to follow the protocol here. Let me make sure I say this for everybody here who is not an attorney. It is not appropriate to ask somebody to tell us what their attorney has told them. They have an attorney-client privilege, and it's not appropriate for the House of Representatives to try to invade that privilege.
Then they can say no.
Well, they are not lawyers, and they don't have their lawyers here with them to give them that advice. And I think it would not be responsible for those
And
of
you
us.
cannot be their lawyer.
I'm not trying to be their lawyer.
Mr. Chairman,
but
Mr. Chairman, I
let
was
me-
only
let me finish-
minute-
Let me finish what I'm saying. Now, those of us that are lawyers understand this is a very serious thing. And some of us are officers of the court, whether we're these folks' lawyers or not. And we've got to be careful, and I don't think it's the intention of anybody on this panel to try to invade the attorney-client privilege. But it is a privilege. It is recognized by the courts, and we should not be invading that privilege. If they want to consult their attorneys and come back to us and give us an answer, that's a different thing. But to ask them, without their attorneys being present, to give us information about what their attorneys have told them, I don't think is appropriate.
Well, Mr. Chairman, I was merely
Really?
trying to clarify whether such communication had taken place, whether she had her own attorney, whether she had consulted her own attorney, or where she was being guided by the franchisor's attorney. And I want to make sure that her interest as a small business owner was being represented, as opposed to receiving guidance from the franchisor's interests. And in this case, because the way this law is written is so perversely against both workers and small business people.
Mr. Takano, you are welcome to ask the questions that you want to ask, and they can give you the answers. But when we're wandering into a situation where we might be asking a non-lawyer to make a decision about whether or not they're going to give up a privilege that is recognized by the courts, I think it is appropriate for us
Well,
to
I had no
interject
intention of
ourselves.
asking for any privilege to be waived, merely whether or not the communication, whether she had consulted her own attorney versus the franchisor's attorney.
Thank you. The chair now represents the gentleman from South Carolina, Mr. Wilson, for 5 minutes.
Thank you, Chairman Byrne, and thank you all for being here today, and particularly Ms. Kennedy. I appreciate the opportunities you provide. The International Franchise Association gives such opportunities, and then from that, you help develop and the members help develop small businesses that provide entry-level jobs for people to have first-time employment, improve themselves, and succeed. In fact, in South Carolina, we particularly recognize this. U.S. Senator Tim Scott had his first job at a Chick-fil-A franchise in North Charleston. And so how wonderful it was that he had that opportunity. And so I want to thank you for what you do. In regard to that, in your testimony, you provided several examples how the joint employer standard has increased the cost for you to run your business. You mentioned that you now provide job application forms, employee handbooks, and recruitment materials that were previously provided by the franchisor. Could you elaborate as how the cost of the joint employer standard is reducing job creation and growth?
Thank you very much. I'd be glad to. The one thing that I can tell you for sure is we keep track in the restaurant business, my restaurant business, of every penny and where it's spent, and we find that the most valuable way to spend our resources on something that's I'm passionate about, which is education and helping our young people get started in their work life. In order to do that, we need good tools. We need to provide them with training documents, standard structures that help them learn different parts and different skills of the restaurant business. It's not as simple as just becoming a cashier and running a cash register. It's about food safety. It's about understanding how to direct employees and manage money and manage inventory. And those skills, given the opportunity to learn them, can help them run any business in the world. The costs for me to do that have gone up substantially. I have to source, find, pay, and produce many of the items that I used to get from my franchisor. Simple things like now hiring banners, flyers that go on bags and on trays, all of those pieces and products that I use to let people know that I am looking for really great people cost me more money to go produce. My handbook, the $9,000, was just a start. Every time there's a change in the work environment, I have to update that handbook. That's expensive, and it's definitely not something that I'm an expert at, and so I have to pay to get the legal representation that I feel I need to make sure that I'm complying with all of the many pieces of legislation and work rules that I'm responsible for.
Well, again, thank you so much. I know personally the opportunities you provided. My third son, Julian, began at Ruby Tuesday and did great work, and then my youngest son started at Atlanta Bread Company serving. So what great opportunities you provide. Equally, Ms. McDonald, I appreciate the National Association of Home Builders. In fact, I, in my real estate practice, was a member of the Columbia Area Home Builders Association, and I still pay my dues.
Thank you.
I know, well, they are very persistent, but I appreciate the jobs created. And it's family-run businesses that span generations such as yours. You discuss in your testimony how small local businesses are negatively impacted by the expanded joint employer rule, and that without having the resources of larger companies, resulting in higher home prices for consumers. Can you explain how the housing market would be negatively impacted by the expanded joint employer mandate?
Absolutely, and thank you for the question, sir. It's exactly where you were headed there, that we have small companies. Small companies don't have the access to in-house lawyers, to in-house HR personnel, and all that it takes to be in business. So we have to rely upon what we can glean from the street or what we have to do in the way of hiring outside counsel on our own. And frankly, in all due respect to Mr. Rubin, he's the first attorney that I've heard that's willing to opine as to what's going to happen in labor law after Browning-Ferris. I can't find an attorney who says, you need to do this, this, and this. The attorneys that I have consulted have said, I can't answer the question yet until there's more case law. We all know that case law means much more legal expense, many more problems for small business owners. So who's going to succeed here? It's only going to be the big builders, the larger people who have larger volume and can afford to have staffs of attorneys to deal with these issues. The smaller subcontractors, the smaller contractors are just not prepared and can't be.
Well, final, again, home builders are great citizens and corporate citizens and business leaders of our community. We appreciate the Home Builders Association. Thank you.
Thank you, sir.
Thank you, Mr. Wilson. The chair now recognizes the gentleman from New Jersey, Mr. Norcross, for 5 minutes.
Thank you, Chairman. Common law to 1935, when the Nlra was passed. From 1935 to 1984, 46 years, working off the same decision, getting decisions from the board, clarifying where it was. Then we had 1984 to 2015, only 31 years. And here we are from 2015 to 2017, or as I call it, back to the future. Because what has happened is we went back to where we were for 46 years of decisions. 46 years. 800,000 franchisees, not one has been considered a joint employer. So I listened to the testimony. I'm trying to make sense. How is it that we can work together to address the issues that we're hearing from you? And the first thing that comes to mind is, Mr. McDonald, you mentioned that the franchisees, or the joint employer decision is hurting the construction industry. How would you reflect on that in the last 2 years, companies have grown, those who are starting? There's an increase of construction companies. Isn't that the exact opposite of what you suggested?
Well, it's the indecision that's going to put an end to it. We're only seeing an increase.
Well, you mentioned that this would keep people from going into business.
Yes, sir, and it will keep people.
But it increased.
Would you like for me to answer the question?
No,
The answer to the question is that we went through an extreme period of negative growth in the construction industry in 08, 09, and 10. And we've seen a rebirth of housing starts. Housing starts have almost doubled in that period of time, and that's what it is, a simple supply and demand issue. I will also say that the protection of workers and labor in our industry is really based on supply and demand. I will tell you right now, because of the shortage of labor we're having,
I want to
no
keep
one's going to treat an employee poorly.
My time, I like to keep a narrow focus of what I was asking you, because the employee is not going to be impacted by the joint decision whether or not he's going to go to work for somebody, and that's the problem that we're having. The fact of the matter is that, particularly in construction, job site safety, it's everybody working together. You're not going to throw that on another employee. That's where all the liability comes in. And that's, quite frankly, the reason why the deaths on the job has been decreasing, because everybody works together. I just want to make sure that when we look at what's going on here, instead of going back to the decisions of 46 years, we're going all the way back beyond what it used to be. So the idea of having precedents that and predictability, you're going beyond that. And I just want to follow up with my last question. When I look at AT&T, now the retail stores, almost 60% of their stores are operated by one of two very, very large subcontractors, completely contradicting what you're telling us today. Mr. Rubin, I was wondering if you could talk about, in a broad sense, the different tactics that are used to erode the employer's obligations to employees and how they might vary depending on the industry.
Varies depending on the industry and the creativity of the dominant company. There are lots of ways to do it. The AT&T example is one. We know through the communication workers how they're able to structure the relationships so that they maintain their control.
Because in the construction industry, the fact of the matter is joint employer is not happening all that often.
Very rarely. Of the 9,036 cases identified by Mr. Fassman that were filed under the FLSA in that 1 year, I bet no more than 2 or 3 included a joint employer allegation. It is a rarely advanced theory, but a critically important theory, which is why we need to preserve it. It's not just that the law went through a 46-year period. Under the Fair Labor Standards Act, this would change law going back 81 years since the FLSA was enacted. Even with the NLRA, this notion of direct and immediate didn't come into play until 2002 in the Airborne Express footnote. So in fact, it's not even 1984. The standard that was rejected in Browning-Ferris was in fact a 2002 standard. It's a period of only 13 years.
Thank you. We need to sit down and work together because these facts are completely opposite of each other. We don't need to go all the way back. We need to sit down and have a reasonable discussion and work this out. I yield back.
Thank you, Mr. Norcross. The chair now recognizes the gentleman from Tennessee, Dr. Rowe, for 5 minutes.
Thank you, Mr. Chairman, and I want to thank the minority staff for their well wishes and flowers you sent me during my recent surgery and continued recovery, so thank you for that. I appreciate that very much. You know, uncertainty, when you have an uncertainty, that creates a situation where people react. And Ms. Kennedy pointed out clearly that the uncertainty of this particular definition of the NLRB, what is a joint employer status, created a chain of effect where she then had to go and create her own book, which cost $9,000, and a continuing recurring cost. That cost could go in, that money you could go into expanding your franchise, increasing wages, growing your business where it is, de novo where it is. So the uncertainty is done, and the fact that something hadn't happened doesn't mean it won't. And so I know exactly, I'm a small business person, and I know I reacted when ERISA law changed. We would do certain things. The fact that it hadn't happened didn't mean that it wouldn't happen. So I'd like to ask you, Ms. Kennedy, and thank you all of you for being here. How much involvement does your franchisor have in your daily affairs of your business and employees? For example, does your franchisor sign the paychecks or hire employees or decide what hours someone will work?
They do not have any involvement in any of the day-to-day interactions with my employees.
And yet this uncertainty has caused them to change the relationship they had with you. Am I correct on that?
I believe you are correct.
And that change created what? An added expense for both you and the franchisor.
Absolutely.
Am I correct on that?
You are.
So I think the uncertainty is important. And look, this is great for employment of attorneys who have differences of opinion, and everything is arguable, I found out, no matter how it's said. So, Mr. Fassman, we've seen an age of e-commerce and the importance of an expedited delivery. What limitations does the new joint employer standard put on companies who may be exploring innovative delivery services or new partnerships with other businesses to satisfy growing consumer demand for rapid product delivery?
Well, that's a very good question, and I think it goes back to exactly what you were saying, Congressman, and that is that it's very difficult to understand exactly what a contractor can do and cannot do under this standard because it's not based upon the facts of the relationship. It's based upon potential or indirect control. That's a question that's only answered in retrospect. That is, I don't know what potential control could be, and as you said, Mr. Rubin and I can argue about potential control in any relationship, and that's probably how we made our living for a long period of time. But, I mean, those things they're just not clear, and structuring a relationship, a commercial relationship, is vital in the areas that you've spoken about, and that's why basically saying, let's go by the facts, let's not go by potential and unreserved or unexercised control is so important.
I want to thank Mr. Byrne for this, to try to put some clarity to this. I had not a franchise business, but I was in my business myself the entire time before I came to Congress, over 30 years. And we contracted a medical practice, and we contracted cleaning services. We didn't do that ourselves, but we contracted that. I expected certain standards to be met and cleaning the office so it'd be presentable the next day. I didn't exercise direct control over that. If we'd have been a franchise, I would have been caught in that uncertainty. What do I do? And I think that uncertainty is clear, and it's costing millions, if not billions of dollars to comply with this uncertainty. And if you've got that many people, 700 and something thousand franchises, 9 million employees, it is a gigantic number. Mr. Rubin, just a question, yes or no, was that $22.7 million settlement a class action lawsuit or just not?
It was a class and collective action under state and federal law.
So what was your fee out of that $22.7 million? How much of that did the workers not get?
The workers got up to $80,000 apiece.
No, I didn't ask
based
that.
on the amount
So
of
what
time.
percent of that $22.7 million went to you and your firm, not to the the affected workers?
In order to litigate that, I don't know exactly how much our firm made, but there were
28, 30%?
There were 5 different firms who had to work on it, who put in more time than we were paid.
20
If you do it on an hourly basis.
30%, 40%, how much?
No. I think it was probably in the low 20s, but we were paid less than our hour. Had we been billing at an hourly rate, our fee would have been more than twice the amount we ultimately received.
I yield back.
Thank you, Dr. Rowe. The chair now calls on the gentlewoman from Ohio, Ms. Fudge, for questioning for 5 minutes.
Thank you very much, Mr. Chairman. Thank you all for being here today. Mr. Rubin, before I give you the balance of my time to respond to Mr. McDonald, who just shared with us a communication between he and his lawyers that has now said that you're an outlier in your thought process. and to address the question that was just asked by my colleague. Of course, we know lawyers get paid. I mean, this is ridiculous. But let me just make a couple of comments, and then I'm going to turn over my time to you, sir. First, we have heard ad nauseum about the decision in Browning-Ferris. As my colleague said, we've had 35 hearings about this. It is interesting that every time my colleagues across the aisle don't like a law, they call it uncertain, ambiguous, unsustainable. Just because you don't like it doesn't mean you don't understand it, and they clearly understand it. And I just want to remind our Chairwoman Fox that intent is a standard that has been accepted in American jurisprudence for generations. It did not start here. And lastly, I just have to say this. I am trying to figure out, for the life of me, what Tim Scott has to do with what we are talking about today. So he worked at Chick-fil-A. So what? I mean, did he bring it up because he's black? Did he bring it up because he thinks Tim Scott might support his position? I take great offense to using a U.S. Senator who happens to be my friend in something so ridiculous. My time is now yours, Mr. Rubin.
Thank you. In response to the questions about uncertainty, first, a bit of background. I try to be well-versed in the law. Before I started practicing, I was a clerk for a Supreme Court justice. I try to be well-versed in the facts because my job as a litigator is to discover and know the facts and apply the facts. And I try to understand cases like the Browning-Ferris decision and the Freshie Advice Memorandum by actually looking to see what's written in those opinions, what standards are applied. You start with the Browning-Ferris decision. It actually simply reiterates the standard that I quoted before about sharing the essential terms and control over the terms and conditions. The standard itself is not objectionable. What people seem to be complaining about, Mr. McDonald and others, Ms. Kennedy, is that they have been advised that there's some uncertainty. But in each of the instances they've described to me, there's no way a litigator would pursue their case on a joint employer basis, which is why of the 9,000 FLSA cases, only a handful were ever pursued on a joint employer basis. What were the facts in BFI? We have to focus on them. BFI owned the plant. It set the shifts. It told the employees where to work. It capped their wages. It decided when they would have to work overtime. It decided how many workers would be working overtime. It decided when to stop the assembly line for breaks. It controlled the line speed. It had the right to veto any wage hike or wage change that Lead Point offered. It trained the workers. It had the power to fire, and in fact, it did terminate 2 workers that it didn't want, and it had the power to fire the entire workforce. Those are the facts of Browning-Ferris. And any lawyer looking objectively at those facts under the standard that has been part of the National Labor Relations Act would conclude that that party should participate in collective bargaining, Browning-Ferris that is, because it had the right to affect terms and conditions of employment. And certainly, we haven't talked a whole lot about the Fair Labor Standards Act, but the Fair Labor Standards Act.
Mr. Rubin, if I could just interrupt you one moment. I really would like to yield the last of my time to our ranking member, if you would allow me to do that, sir.
Thank you. Mr. Rubin, I think you can finish up that statement, but include in that if you have a Fair Labor Standards Act violation and somebody comes in and says, I'm not an employer under this definition, and then the other guy comes in and says, I'm not an employer under this definition either, is it possible that nobody's responsible?
Wow. In fact, as I look at the language of the Act, that is possible. Imagine this circumstance. Company A is in charge of hiring. Company A and B share responsibility for firing, and Company B also sets wages. The worker says, who's my employer under this definition? Well, does either Company A or B control the essential terms, which are then listed? There are 9 of them in the conjunctive. No. So in that case, there may be no employer.
So if there's a finding that I wasn't paid overtime, nobody owes it?
neither company is a joint employer, and arguably neither is an employer at all. What uncertainty, this language explodes uncertainty to the point where every single case where any element, any term or condition of employment is shared, there's going to be litigation over whether either company could be
Mr. Rubin,
an
you're going
employer.
to have to wrap up again.
I think I've answered the question.
Good, thank you. Thank you. All right, the chair now recognizes for question for 5 minutes the gentlewoman from New York, Ms. Stefanik.
Thank you, Mr. Chairman. Mr. Fassman, in the amicus brief submitted by Microsoft in the Browning-Ferris case, Microsoft argued that the NLRB's new standard will discourage companies from implementing policies and initiatives that go above and beyond their legal requirements. For example, market leaders with complex supply chains would be penalized simply for implementing policies on responsible product sourcing or human rights, as well as labor and environmental standards. In this Congress, I've worked on the Millennial Task Force, which I chair with my colleague, Mr. Messer, who also sits on this committee, and we have explored how today's companies are changing business models to attract and retain the largest segment of our workforce, millennials. What companies such as PricewaterhouseCoopers, Uber, and Google are telling us is that millennials are looking for companies that have a purpose larger than the business. Corporate citizenship is now more than ever a key factor in millennials' interest in a job. So how does this new joint employer standard actually chill positive corporate policies by American companies, specifically large companies with complex supply chains?
I think that that's a very good point, and the answer is that large companies with supply chains and with innovative programs under the standard that the Labor Board has created have to be extremely careful about the control that they exercise, that is, implementing policies from the top down. That seems to me to be a very doubtful enterprise if, in fact, this is the standard, because the more control you retain, the more you say, you should do this, this is how we want to do this, the more likely it is that you're going to be considered a joint employer.
Is there any more specific example you can provide?
I can't think of any sitting here right now.
Okay, thank you very much. I yield back.
Gentleman yields back. The chair now recognizes the gentlewoman from Oregon, Ms. Bonamici, for 5 minutes.
Thank you very much, Mr. Chairman, and thanks to each of the witnesses for being here today. We've had this conversation many times. I am one of the people here on the committee who used to practice law as well. I represented franchisees in disputes with franchisors, and I certainly know and appreciate the franchise model and the opportunities that it creates. Before that, though, before law school, I worked in my mom's small business, and I look at the title of this Save Local Business Act, and, you know, we all want local businesses to thrive and succeed. This bill is not the way to do it. You know, and as we've heard multiple times, this BFI case that we've talked about so much does not upend the franchise model. And as we've heard again this morning, that was made clear in the Freshie case. A franchisor is not a joint employer if they act like a franchisor by protecting brand standards. And yes, a franchisor can provide guidance, and there was an advice memo from the NLRB on that. Employee handbooks, payroll services, those things, as long as they're optional, do not make a franchisor a joint employer. And you know, that if they're going to act like a joint employer, they should be treated as a joint employer. And Mr. Rubin, you've talked a little bit about why a fact-specific standard is important, and I really appreciated also your response to Ranking Member Scott's question, because as I read this language with the and, all of those have to be met to be a joint employer. Why is it important that there be a fact-specific standard when it's assessing joint employment?
Under any standard, the current standard under the FLSA, the NLRA, state law, other federal statutes, it all depends on the actual relationship between the parties. There are so many ways franchisors, franchisees, lead companies, supplier companies can structure their relationship. That's a good thing. We welcome flexibility in how companies operate and how they interact with each other.
And those are typically spelled out in the franchise agreement, correct?
Yes, and it's set forth in as clear language as they can set it forth, and the courts must look at the specific factors and see what happens both as a matter of contract, and then on the ground in terms of the actual exercise of control. That's why it's fact-specific. You can't just say because you have a relationship of user, supplier, or franchisor or franchisee, you are or are not a joint employer. You have to look at the facts on the ground and the legal relationship by contract under the law in the jurisdiction under the particular statute. That's how you analyze cases.
I certainly agree that the language in this bill would make it much more confusing and create much more uncertainty about who is a joint employer, what entity is a joint employer. And Mr. Rubin, we're sitting here in 2017 and there's still a pay gap between women and men. It's difficult for individuals to prevail in Equal Pay Act claims. Congress did pass the Lilly-Ledbetter Fair Pay Act in 2009. There's also the Paycheck Fairness Act, which I support, that would further strengthen the right of pay equity. If this bill, the Save Local Businesses Act, were to pass, would it make it more difficult for a worker to succeed in an Equal Pay Act claim? If so, how?
It probably would. That's another great uncertainty with the way this bill is written. The Equal Pay Act is incorporated into the FLSA. Right. As a result, it adopts the standards set forth in the FLSA. It depends on Congress's intent at the time, and that's why there's going to be litigation over it. But certainly, if this bill changes the definition from what it's been going back to the early 30s to what is proposed here, it will affect the Equal Pay Act, make it far more difficult, in fact, I think impossible, to prove joint employer relationships. Same thing will happen under the Family Medical Leave Act, and certainly under the Migrant and Seasonal Agricultural Worker Protection Act, which also bars the FLSA definitions. So we are going to have an explosion of litigation, more uncertainty, more expense for franchisors, franchisees, contractors, and the like if this bill were enacted.
And I know it's been asked before, but just to clarify, how many cases are you aware of where a franchisor has been found to be a joint employer with its franchisees under the Fair Labor Standards Act?
0.
Thank you. I yield back the balance of my time.
Gentleman yields back. The chair now recognizes the gentleman from Georgia, Mr. Allen, for 5 minutes.
Thank you, Mr. Chairman, and thank you, witnesses, for enduring this. As you can see, there's a very, very difference of opinion. I will tell you, Mr. McDonald, Ms. Kennedy, I'm not going to warn you of the risk of running your business. I'm a small business person, and I for years, and it's a construction business, and I pretty well understood the risk, and I'm not going to try to tell you how to run your business. I think that's the great thing about this country is you decide what's best for you and your employees, and we need to keep it that way, in my opinion. As far as this law is concerned, obviously we have 2 lawyers who can't agree here today. So ain't America a great place to live? We're all trying to figure out what is best for the people and the citizens, the great citizens of this country. But it is pretty dynamic right now, this economy, and the innovation is very dynamic. And frankly, the 5-year business plans are a thing of the past. 1-year business plan, maybe 6 months, I don't know, maybe 30 days is what we have to deal with in the business world because your competition is getting, it's just difficult out there. And but that's good. That's good for the customers. And we haven't talked much about customers here today, but that's who we work for. But going back to these models and what we're trying to clean up here as far as trying to make at least the lawyers understand, again, we've got the lawyers disagreeing on, well, there's going to be more litigation after this law versus, well, we've got to have this to decrease litigation. Mr. McDonald, as far as your relationship with your subcontractors, and also Texas is a right-to-work state.
That's correct.
Yeah. In fact, going back, Mr. Veschman, as far as you got states in this country that are right-to-work states, and you got states that are not right-to-work. This Browning-Ferris thing, obviously this was in California. Georgia's a right-to-work state. Texas is a right-to-work state. How does that? How do you deal with that?
Well, I think it's a different. So is Michigan, by the way.
Yeah.
And I think I think the real question in any of these situations is who the employer is. And I don't think that that's necessarily directly related to the right to work issue at all. But I would like to, Congressman, I would like to utter some words that haven't been said during this hearing, because everybody's talked about there's never been a franchisor who's been found to be a joint employer. There's been 145 days of hearing in the McDonald's litigation on just that point. General Counsel Griffin is using the Browning-Ferris decision to prosecute McDonald's and all of its franchisees across the country. There is an air of unreality here in the questions that have been asked. I mean, to say there hasn't been a franchisor who has ever been found to be a joint employer, I mean, tell that to McDonald's, who's spent the last 145 days and continuing in hearings on this point. I find it unbelievable that nobody's mentioned that. I just did.
Yeah, and I'm glad you brought that up. I was going to get to that as well. As far as the right to work situation, Mr. McDonald, I know one of the questions is whether you're working union or open shop, and at least in a right to work state, you can have two gates, and you can work both union and open shop subcontractors. Do you have any subcontractors who work under that scenario?
Yes, sir, we certainly do.
You do?
The people who provide our elevator services, Theisenkrump are union, and even their maintenance personnel are as well, and we work hand in hand with them.
Right. So we don't have any issues there. These were some concerns that were brought up about. And I know and I'm not sure in a state it's the not right to work state, you don't have that option. Is that correct?
I think that that's correct. I think that you don't have that option.
Okay.
And it's a state-by-state situation, and you bring up a wonderful point that a lot of state law is going to be trampled as we try to unravel all the litigation around this that's pending, that's working quite well, and it's working well in Texas.
Well, obviously, we're here to try to dismantle regulatory involvement in the process. We think that's the most innovative, productive way for this country to grow and to get people to work. Thank you for your testimony.
Gentleman yields back. The chair now recognizes the gentlewoman from North Carolina, Ms. Adams, for 5 minutes.
Thank you, Mr. Chairman, Ranking Member. Thank you as well, and thank you to the witnesses today. What's interesting to me is that the very people that my colleagues claim to be advocating for with the support of H.R. 3441 are those who suffer the most if this bill is enacted. The focus on the harm the joint employer standard does to franchisees is a red herring, because the National Labor Relations Board has really never found a franchisor to be a joint employer. So it seems that all this bill does is create a scheme that would give franchisors the power to skirt labor and employment laws while leaving franchisees increasingly exposed to lawsuit. So I have a couple of questions. Mr. Rubin, my colleagues claim that H.R. 3441 creates certainty for franchisees in the joint employment context. So could you explain why this may not necessarily be the case, and what uncertainty might arise from narrowing the standard in this way?
The only certainty created by the bill is, as Representative Scott was pointing out, it is certain that no franchisor or other large company could be held liable as a joint employer. It creates uncertainty because there are still lots of other federal statutes and lots of state statutes that have a range of different standards. The standards proposed here still have to be applied on a fact-by-fact basis. There is no way, no court at any time since the Supreme Court in the Rutherford in 1947 has ever tried to analyze a joint employer case without looking at the facts. There is always uncertainty until the facts are developed. A well-counseled franchisee, small business, large business franchisor will know how to avoid responsibility by delegating all control to the other business, or to take on responsibility as it should if in fact it does control the workers.
Okay. So, Mr. Rubin, Ms. Kennedy is concerned about the impacts that the common law joint employer standard may have on her business, and believes that common law standard limits her autonomy as a franchisee and increases costs. Well, what's your view?
The common law standard has been in effect for well over 100 years. As the board in Browning-Ferris emphasized, excuse me, looking at the restatement of the law of agency, which sets out the common law principle, it is a fair and appropriate way to determine when one company is acting on behalf of another. That's what agency is all about. Where the franchisor directs the franchisee to do certain things, and that's indirect control, it is responsible for what it has directed the franchisee to do. It's as simple as that. Common law was developed, initially the principle, for when a company is responsible for its employees' wrongful acts against someone else. There was strict liability imposed on the master for the acts of the servant. The statutes have been adopted in order to protect the employees of the master, so the master doesn't deprive those workers of their rights. And that's all the joint employer doctrine is about, ensuring that the responsible parties are held liable and responsible for bargaining for and making whole employees who are deprived of fundamental statutory rights because of the larger company's own actions.
Great. Thank you very much, and Mr. Chair, I yield back.
No one yields back. The chair now recognizes the gentlewoman from Georgia, Ms. Handel, for 5 minutes.
Thank you, Mr. Chairman. Thank you to all of the witnesses here today. I appreciate the insightful testimony. For Mr. McDonald, with the aftermath of Hurricane Harvey and now with Hurricane Irma through Florida and into Georgia and South Carolina, how important will it be for builders to be able to find subcontractors to work with the rebuilding efforts? And does the expansion of the joint employer standard impact that in any negative way?
It will impact it in a negative way, because we can't do anything that impedes our ability to get more folks to come to work. We were having problems getting people to come to work before the storms in these areas because we'd have an economic rebirth since the 2008 crash. And so now it's just being exacerbated by the fact that we're not only trying to produce new housing, but we're trying to repair the damaged housing, get people back in their homes.
Great, thank you very much. Ms. Kennedy, like you, I also am not an attorney. In fact, we actually share a common history in that I, too, started out as a secretary and worked my way up. One may have an opinion about the direction of my career since then, but I want to say that I have tremendous respect for lawyers both on this panel and across the country, at the same time having the viewpoints of people who are actually on the ground having to implement these types of regulations that come through from and giving us a very practical, real-world impacts of what you're trying to deal with, as well as Mr. McDonald, is incredibly important, and so I appreciate that you're here. One question for you. You spoke about owning stores in Iowa and Minnesota. If you were thinking to expand into Wisconsin or Illinois, as you know, there would be different definitions there. As a result, is it possible that a different test for joint employer liability under FLSA would apply? As a business owner, would it be helpful, more helpful, or less helpful to ensure that we have a uniform national standard such as the one created in this bipartisan, I would like to add, Save the Local Business Act, and how important is that consistency and uniformity to you?
Thank you very much. It would be very helpful to have one clear definition of what joint employer means across any state line. Working in 2 states right now, it's difficult, challenging. I learn fast, and often when things change from one, we share a border. That's about it from Iowa to Minnesota. If I do want to expand, and I hope to, in other states besides the 2 that I'm in, it would be very helpful to have one specifically clear set of languages that help guide us in how we look at joint employer and in fact, any other type of regulation as we run our businesses.
Great. Thank you very much, Mr. Chairman. I yield back.
Gentlewoman yields back. The chair now recognizes the gentleman from California, Mr. DeSaulnier, for 5 minutes.
Thank you, Mr. Chairman. I'd like to maybe make just some macro comments. I'm not an attorney, and this is maybe in the context, Mr. Chairman, I hope you don't take any offense. It might have been easier on everyone, but not as good for attorneys if we just went back to the more traditional employer-employee relationship. I know that the Obama administration, the Department of Labor, have been working on a study that showed that up to 70 million Americans no longer have a traditional employer-employee relationship. So in that context, we have this debate. Having worked at fast food restaurants, and I'm going to date myself, when I was in college in the 70s, it was a traditional employee-employer relationship. Having owned restaurants for 35 years, Ms. Kennedy, I understand the pressure you're under, but they were independent restaurants, and I wonder about this rule and how impact it might have in the real world, as some of my colleagues like to say, having worked in what their definition of the real world is on independent restaurants, because with all due respect to McDonald's, I never felt like, even though I was in fine dining, they wanted me to stay in a business any longer if they could get my business aside. So, Mr. Rubin, in the context, the larger context, I'm just worried about this erosion of worker protection. I wish it could be clearer. I share that with the majority party. I know that former Secretary of the Labor, Secretary Reich, likes to argue that we should make it simpler just by saying employee-employer relationship is if you receive 80% of your compensation, you were employed by that employer. It strikes me that for everybody, that would be easier, knowing we have to have something for these unique franchise relationships. But maybe you could just expand on sort of more in your world, what happens with other employers as they try to compete in a world where you've got this disadvantage in my mind's eye when I'm trying to compete with somebody who pays less in terms of wages and benefits because they're contracting out.
Right. That's an interesting perspective and one we haven't addressed. I, too, started my career as a secretary, my first job out of college, and spent a lot of time in a small business, Reuben Hardware and Son, in Dorchester, Massachusetts, founded by my grandfather in 1922. I understand the impacts on small businesses, and I particularly understand the impacts on small businesses that try to follow the law. And that's the problem we have here. We'll call them high road businesses. That's a nomenclature. They shouldn't be called that. They're simply law-abiding businesses, as every business should strive to be, and the overwhelming majority do. The problem they face is competition from companies that don't follow the law,
right,
who are able to save labor costs by what has been called wage theft, by taking money, sometimes in small amounts, but in the aggregate large amounts, from workers not in compliance with the FLSA and other statutes. And what the joint employer doctrine does, and actually we see it more often in the agricultural context. More than half of the cases that have actually been litigated and found joint employer have involved farm workers who have been ripped off by farm labor contractors. But we see it in a range of industries where labor is a significant element of the employer's costs, and where the reason the company is cheating its workers is because the squeeze is on from the higher up the ladder company. So the contract doesn't provide the small business enough profits, yet demands that it acts in a certain way, certain productivity quotas that can't be done legally. That's when that company caught in the middle, that small business, has to find sometimes violating the law, and that adversely affects every other small business. So it's not just the small businesses that themselves are in a joint employer relationship that would be affected by this bill. Every small business that faces the competitive squeeze from other small businesses that aren't legally compliant because of their relationships with other companies are going to be harmed by this bill.
And I just, one other aspect of that, and Ms. Kennedy, one of the pressures I felt as I went longer in my restaurant career was disposable income. So this dynamic and this race to the bottom gives workers, consumers, less disposable income. So I always looked at the trade magazines to look at that in terms of housing costs, transportation, healthcare costs, because there's less money for them to spend in the marketplace. And Mr. Chairman, just in conclusion, maybe Mr. Rubin can add some comments to this. I did want to note that McDonald is still pending and was brought under the 1984 Joint Employee Standard, which was pre-BFI, if I'm correct. Mr. Rubin, do you have any comments about that?
Yes, and the facts of the case are very McDonald's specific, are the facts of other cases against McDonald's. But yes, it's based on the old tried and true standard.
Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Desaulniers. The chair now recognizes the gentleman from Wisconsin, Mr. Groffman, for 5 minutes.
Yeah, I'll start off with Mr. Fossman. It's kind of a difficult topic because you normally think small business is the backbone of America, and of course, government for a long time has been waging a war on small business, trying to drive them out of business, just punish them. They hate them. But could you just, in general, a lot of small business today are franchisees. Could you give me, in general, your opinion of what will happen to small businesses as this goes into effect? Will more of them be driven into becoming corporate stores and more employees be forced to work for large corporations? Will that be something that will happen in the long run?
Yeah, that is, of course, where this ultimately goes. If you are a large franchisor and you're found to be a joint employer with franchisees across the country, you may have thousands of collective bargaining agreements that you have to negotiate, and that's untenable. So what do you do under those circumstances? Well, there are certain things you could do, but one of them is you could say, well, we won't have franchise. We
become all corporate stores.
Yeah.
Just like we do in so many other industries. Correct. The government will, their hatred for the small businessman will be such, they want everybody to have to work for a large corporation. That's what's going to happen, right?
Yes, I mean, that's the logical thing to do, is to say, look, we can't do this. We can't negotiate, 3,000 franchise labor contracts. It's just an impossibility.
Not to mention, you don't want to be personally on the hook for what's going on with somebody who you're not supervising yourself.
Well, that's absolutely right, and that really goes back to what we're talking about here. It's hard for a business that has a contractual relationship with another business and says, look, you run all of these things. We don't want, as is the case with Ms. Kennedy, you hire, you fire, you pay, and you're responsible for this, to be told after the fact by a federal agency, oh, but by the way, you're a joint employer because you have the potential to control that relationship. I mean, that just makes no sense. The parties do this, and with all due respect to what I've heard today, companies do this not to evade the law. They do this because this is a legitimate and important business model in generating jobs throughout the United States. It's not a nefarious way to get around paying employees what they're entitled to under the law.
Well, Ms. Kennedy, I'll ask you, I guess you own several Taco Johns, but you probably started out with one.
Actually, I bought the company in 1999, and we started out with more restaurants than I have today. I started with 14. I'm down to 9.
Oh, okay.
Yeah.
I'll ask you, though, as somebody who is a franchisee, would you feel you were a small businesswoman if, I guess, you lost control of the employer-employee relationship, or in which more and more the employer-employee relationship, assuming Taco John's would allow you to continue to exist, would be directed from the corporate level?
In effect, it would make me a manager for them. If they are going to be responsible for employees that are technically my employees in my business, why would they want to carry all of that risk if they couldn't direct every single action of those employees? And that's really what's at odds here today, is that uncertainty over whether or not is it possible that they could take over control of my employees, because they might be held responsible in the end for what they do.
Now, we're looking at joint employer rule today, Ms. Kennedy, but we sit on other committees, we deal with other sort of businesses, and this idea of hating small business and forcing them to a position in which they ultimately have to get bought out by the big corporation is something that we see in other areas, just in the restaurant business. Do you know why the government hates small business? Could you tries to drive them out of business? Could you maybe speculate as to why that is, why their politicians would be in favor of this rule?
I guess I can't, I won't speak for or to that. I can tell you from my perspective, though, that it's easier to control the larger.
Easier to control.
Yeah.
Control the big business than control the little guy. You lose touch, of course, with the local community. I'm sure you give money to the local charities and participate in those events. And, once big Mr. Nothing against Taco John's, once big Mr. Taco John's gets out there, they're not going to be helping out with a local float at the local parade or whatever. It's a shame that so many people are trying to drive people like you out of business. Kind of a shame that the government is doing that. I guess my time is up.
Your time is up. Gentleman yields back. I now recognize myself for 5 minutes for questions. Mr. Fassman, we've heard today that there have been virtually no findings of joint liability of franchisors. And yet, there are press stories of investigations and cases regarding a number of brand name franchisors, and you mentioned the McDonald's case. Is it accurate to say that franchisors and franchisees have no reason to worry under this BFI standard?
Absolutely not. It is inaccurate to say that, and the reason to worry, of course, are the things that we've been talking about today when we've actually talked about the bill. The Browning-Ferris decision is, as I said, is completely allows the Labor Board to come in and say after the fact you're a joint employer based upon evidence that was not there, not on the way that you've run your business. So I would be remiss in not saying that this is a standard that all businesses, not only franchisors, but all businesses should care about. And Mr. Chairman, you've made it very clear and said that all you have to do is look at the McDonald's prosecution on this theory, and I don't agree that the McDonald's prosecution was brought before Browning-Ferris, but I can virtually guarantee that the General Counsel will argue that Browning-Ferris should apply under that ruling or in that case. So I don't agree with the proposition that this has nothing to do with it.
Well, it seems to me that the game here is to get a favorable decision in the McDonald's case and then use that as precedent to go after franchise or franchisee relationships throughout the country, large, medium, and small. Don't you agree?
I agree with that. I think that that's why it's being brought.
So would you agree with this assertion that prior to Browning-Ferris that there was certainty under the National Labor Relations Act about who is and who is not a joint employer?
Well, I think that, yes, I think that there was certainty in the sense that there were 30 years of history. All of these cases, as Mr. Rubin rightly points out, are fact-specific, but we at least knew what the standard was. I do not agree, by the way, that there was a common law standard for 46 years before that period of time that was applied under the National Labor Relations Act. I think I've read all those cases. And if one can figure out what the standard was, you're better than I am and a better lawyer than I am. Those cases were all over the place. And even the board said about its prior decisions that it was somewhat amorphous what test we used. So this standard in 1984 brought clarity, brought certainty, balanced the rights of employees, employers, and labor unions in an appropriate fashion.
And what did the Browning-Ferris standard do to that clarity and that certainty?
Well, it destroyed it. It destroyed it by introducing these after-the-fact, non-factual, contrafactual possibilities about potential control and indirect control. It just threw everything into uncertainty, and it will literally take, if this standard continues, it will literally take another 30 years to figure out what it means.
As opposed to going back to the old standard under the bill that we're talking about today and having that clarity and certainty that we had before.
Yes, I agree, Mr. Chairman.
Ms. Kennedy, the American Action Forum, a Washington think tank, just released a study citing a downtrend in growth in the hotel industry, which is heavily reliant on franchises. This could be attributed to expanding the joint employer standards. Do you think a similar downturn could occur in the franchise restaurant industry based on the expansion of the joint employer standards?
I do. I sit here today with that exact position. I am waiting before I start construction on another site. I just finished building one, got it open successfully in January, and now I'm on hold. I want to make sure that what I build is mine. Under all of the laws and all of the history that I have, 33 years as a franchisee or an employee of a franchisee, everything seemed like we were together in this idea of franchising, and now with this, the question is out there. Will they be able to take over, in essence, my business because they might be responsible for my employees? I'd like to point out, too, and I'm reminded that there are hundreds of charges against franchises pending at the NLRB, waiting on the McDonald's decision. So it might be fair to say that there aren't any today. That probably isn't going to be the case once that decision is made.
Thank you. And that comes to the conclusion of our question and answer. I would like to thank our witnesses for taking the time to testify before our subcommittee today. It was excellent testimony, got great information out there. I would ask unanimous consent to submit for the record a statement from the House Committee on Small Business, Chairman Shabat, in support of H.R. 3441. Without objection, it will be entered in the record. Okay, Mr. Connor, do you have any closing remarks?
I do, Mr. Chairman. I would like to thank the witnesses for their testimony today, and in particular, I want to thank Mr. Rubin from my home state of California for clarifying some things for us. And I just want to say that too many Americans can't afford to buy a house, send their children to college, or save for retirement. It really should not be this way. American workers' productivity has led to tremendous economic growth, but unfortunately, the rules are written so that the economy delivers only for those at the very top. Here in Congress, we have the power to fix that. Unfortunately, we seem to have our priorities mixed up. We've held numerous hearings on how to undermine our nation's unions and fundamental labor protections. If we spent the same amount of time in this committee working towards building up our nation's workforce as we have spent on destroying unions, I believe we could have come together on a bill to dramatically scale up investments in our nation's workforce through registered apprenticeship programs. H.R. 3441 is not a good deal for small business owners or small franchises, and it's an even worse bill for workers. I hope we can work together to refocus our priorities to support and strengthen the rights of working people in our modern economy. And Mr. Chairman, at this time, I'd like to ask unanimous consent to insert into the record the slides that Mr. Norcross and I referenced in our opening statements.
Without objection, so ordered.
And I'd also like to ask unanimous consent to insert 2 letters opposing H.R. 3441 from the AFL-CIO and the other from the collectively from the Teamsters, SCIU, UAW, UFW, UFCW, and the USW.
Without objection, so ordered.
Thank you, Mr. Chairman. And that concludes my, my closing statement.
Thank you, Mr. Takano. Well, this has been very useful and helpful, I think, both to the committee and to the House as we consider this particular piece of legislation. What's really going on here is this is a game. I think we all understand what the game is here. You just heard the 2 letters that were entered into the record from the largest labor unions in America. It's an effort by the labor unions to try to organize where they haven't been able to organize before. And it's a very calculated game. It started with the Browning-Ferris decision, but certainly the Browning-Ferris decision is going to be used, is being used today in the McDonald's case, to try to get precedent to use to come in and interfere with the employment relationship of small businesses. Let's make this very clear. This is going to hurt small businesses. I don't hear from big businesses about this. Big businesses have lawyers and accountants and all those people to take care of them. I hear about from people like Mr. McDonald and Ms. Kennedy from my district and all over America, and they know that this is going to hurt them. More importantly, they know what's going to hurt their employees. This is not about the employees of small businesses or the small businesses in America. This is about the big labor unions in America trying to find a way to try to claw themselves back into the position they were in years ago. labor unions have continued to lose their percentage of the American workers that they represent, even after 8 years of a very favorable administration. And this is one more effort that's their attempt to try to get back into some sort of position of strength in America. I would assert the only way they can get back into strength is by changing their model, not by interrupting or interfering with a model that's worked for small businesses and the employees of small businesses throughout America. So I think, if anything, the testimony we've heard today has underscored the need for this piece of legislation. I will say to my colleagues that I have open ears and open minds. If they have some suggestions they want to make to me about changes they think that would improve it, I'm happy to listen. But based upon what I've heard today, it simply has underscored what I've been hearing for months now, which is that we desperately need to pass this law, get certainty and clarity back into that employment relationship, and help small businesses throughout America. There being no further business, the subcommittees stand adjourned.